Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about a recent controversy that has erupted after a statement in this speech was given by Justice Shekhar Yadav from the Allahabad High Court. So what is the controversy, what kind of remarks he has made, and because of this or such kind of remarks, question also has been raised about the code of conduct that should be followed by the judges and whether his statement deviate from such code of conduct. So we are going to discuss in detail about what are the general code of conduct that the judiciary and its members have to follow, what are the implications if someone deviate from such code of conduct, what is the process for the impeachment of the judges, and if impeachment is not done, what are the other rectifying measures which can be taken by the Supreme Court to ensure that such judges are punished. So let us try to understand this topic in more detail. Now, to give you the context of discussion, recently a comment was made by the Allahabad High Court Judge Justice Shekhar Yadav against or basically targeting the Muslim community at an event, and it has drawn a huge public flag both from the opposition parties as well as the civil society members, and not only that, even from the All India Lawyers Union and Association. The event in which he has given the speech or was participating was organized by a right-wing organization, that is VHP, that is a Vishwa Hindu Parishad. The event was organized in the High Court premises itself. So first let us try to understand that what is the statement that he has made. So his speech lasted somewhere for about 35 minutes in which he has talked about and touched a lot of points, but the three major remarks that he has made which has caused flag in the society is about, first of all, the majoritarian, where his speech was having a tone of majoritarian pleasing or appeasement. So he said that country would function as per the wishes of the majority living in the Hindustan. Second, he has said that targeting and comparing two communities, largely from his statement, he is comparing, as we can see, he is comparing largely the Hindu community and Muslim community. So where he is saying that while children of one community are taught kindness and tolerance, the same will be difficult to expect from the children from other community, especially when they witness the animal slaughter. Obviously, he is talking about the eating of the meat or consumption of meat, beef, that is done by the community. Second, he has talked about that the uniform civil code will very soon will be brought in India. The days are not very far. Uniform civil code, in simple terms, if you understand, refer to such kind of code which relates to the personal matters of each religion, and it is uniform for the all the religions which are present in India. And these codes largely govern the matters related to the marriage, divorce, separation, or we can say the transfer of property, succession, and all these kind of things. So to have a uniform civil code, he said that Hindus revere women as goddesses, even as member of other community practice polygamy, halala, or triple talaq. And in this context, he also has used a controversial or derogatory term, as many people call it, to refer to the Muslim population or a section of Muslim population. Now, as a result of his statement and speech, it has drawn criticism from all sections of the society. First of all, you have the All India Lawyers Union. It also has basically sent a petition and sent a request to the Chief Justice of India to take and look into the matter. So it has said that the comment done by the judge or given by the judge lean away from the democracy and toward a Hindutva Rashtra, which the All India Lawyers Union says goes against the principle of constitution, which promotes and focus upon secularism, as we know. Second, the Campaign for Judicial Accountability and Reform, an organization which is led by a well-known, what you can call as lawyer, Prashant Bhushan. So he also has alleged that such kind of remarks, when made by a judge no other than the High Court judge, basically is a participation in a right-wing. First of all, his participation in a right-wing event is what he has objected against. And second, the communally charged statement that he has given were a brazen violation of the oath of office that the judges take before taking the judgeship. And third, Supreme Court Bar Association President and a well-known advocate, well-known what you can call as the politician of India, was also the Union Minister during the time of UPA regime, Kapil Sibal. He also has shown his disagreement and dissatisfaction with such kind of statement, and he is even talking about impeachment of the given High Court judge to rectify the matters. So that is how we can understand the response that we have seen from all different sections of the society. Now, when we talk about the discussion is regarding the judicial ethics, whether the judges follow ethics or what kind of code of conduct and code of ethics, moral principles they have to follow, both in their private life as well as in their personal life, as well as in the public life. Now, we talk about the Indian judiciary itself. The power of Indian judiciary basically draws from two fountains, as experts argue. The first fountain, obviously, is the acceptance, the wide acceptance, the public acceptance of the authority of judiciary, where everyone believes that if justice cannot be done in the government offices, if justice cannot be done in the police what you can say is the police stations or in the jails or in the prisons, finally the justice will be done and will be served at the court by the honorable judges. And second is why there is a wide acceptance of the authority of judiciary. Why so much respect is given to the judges and judiciary and the courts in India? The reason is because the judges and the judiciary largely has been able to maintain their integrity, and that is makes them reliable in nature. When you talk about the term integrity, it basically refers to what you can call as a continuity in the actions and whatever you say. That means you do exactly what the moral code says, what the ethical code says, or what you are expected to do. Integrity is something that we can also understand as opposed to another term that we use is hypocrisy. So both are on the other end of the spectrum. So judiciary in India is known for its integrity. That is why it is widely accepted, and that is why it is deriving, and that is where it is deriving its power from. Now, the experience gained over time has led the judiciary to codify the best conventions of judicial conduct, both in and out of the court. And in this context, the restatement of the values of judicial life is what is believed by the judges to be the primary code ethics that govern the behavior of the judges or any judicial member. So let us try to understand what these codes basically says. The first important code that it talks about, the first important point that the code talks about is the impartiality of judiciary is something that they have to ensure, because the behavior of judge, if it deviates from the impartiality, the practice of impartiality, it will shake the faith of the people in the judiciary. Second, any act of a judge of the Supreme Court or High Court specifically, as if I remind you, the topic that we are discussing about relates to the High Court judge of Allahabad High Court, whether in official or personal capacity. Now, this is a very important point. It is not that you are allowed to do something in the personal life which you are not allowed to do in the public life, because judges, for example, are what you can call as the holder of public offices. So whatever they do, whether in the public life or personal life, is always in the eyes or the gaze of the people. So they cannot do anything either in official or personal capacity which erodes the credibility of such perception that the people have, that the Supreme Court, High Court, or any court for that matter is upholding the values of impartiality. When you go to the court, the judge will not look at your race, will not look at your caste, will not look at your class, will not look at your religion. Rather, the justice will be served to you based on the what you can call as the evidences, facts, and the matter concerned. So a judge must at all times be conscious that he is under the public gauge. At all times, he is a holder of public office. Thus, his actions should not deviate from the code of conduct. Apart from that, the other principle that has been accepted by the Supreme Court in the 2014 largely is the Bengaluru Principles of Judicial Conduct 2002, which said that both, again same thing, in and out of the court, a judge have to maintain the impartiality and they have to uphold the confidence of the public in the legal professions and the judiciary. Second, they also has talked that it does not mean that judges do not have the freedom of expression. They do have a freedom of expression, but this freedom of expressions that they have been guaranteed under the constitution should also be seen and should be balanced with the dignity of the judicial office and the independence of the judiciary. The statements and the acts of judges should not compromise on these two principles, and by doing so only they can exercise their freedom of expression. And third, a judge to be aware of and understand the diversity in the society and treat all equally, because in the personal life, this is very simple to understand. If in a personal life a judge is having a bias, obviously this bias will reflect when he is dispensing justice in his courtroom. And that is why it is important that in both personal and public life, the diversity, the principles of constitutions are adhered to by the honorable judge. Now, if we talk about the Kapil Sibal, who has demanded that the particular judge should be impeached, let us try to look at what is the process of impeachment of a judge, especially the Supreme Court and High Court judge in India. So first of all, the impeachment can be done by the order of president after a successful process of impeachment, and the ground of impeachment is just single: proved misbehavior or incapacity. That means he has been involved in such behavior which is considered as a misbehavior, and it is not only alleged but rather the accusation has been proved definitely. And second, if due to his mental faculties, weakening of mental faculties, physical faculties, if he is not able to or capable to basically serve his duties. Second, this impeachment can only be done if the motion is passed by the special majority of the total membership of the House. Special majority here refers to more than 2/3 of the members present and voting. That is what we can say, 2/3 of the members of the House present and voting, and also supported by 50% of the total strength of the House. And third, except on the removal motion, the Constitution basically prohibits that a judge's decision, his actions cannot be questioned in legislation, or his allegation, whatever allegations is being made by him, by the public or the media, should not be discussed in the legislature unless and until the discussion is on the ground or for the ground of impeachment or for his removal. So this is what we can call as a security or security guarantee freedom that has been guaranteed to the judges in the Constitution of India. Now, apart from the impeachment, the Supreme Court in 2014 basically has also put in the public domain an in-house procedure to basically ensure that the judges' decisions can be rectified or the punishment even can be given to them. This was formally adopted in 1999. Now, what is this in-house procedure? So, for such judges who face a serious allegations, now if these allegations are true, is proven, they are given an opportunity to take voluntary retirement. Now, why voluntary retirement? Because obviously it will spare them and as well as the judicial institutions the public embarrassment if impeachment indeed occurs and is finalized. Third, how this in-house procedure works. So now suppose any allegation, as in this case we have seen, is being made on the judge. Now any person, aggrieved person or institution, they can put a complaint against a judge either to the Chief Justice of India, to the Chief Justice of the respective high courts, or directly even to the President of India. Now let us try to understand how this procedure will work. Now suppose you take instance where the Chief Justice of High Court has been made aware about the allegations against a judge. Now the Chief Justice of High Court will look into the matters, will investigate the matter, and will ask the accused judge basically to give the reasons or basically explain the situation. So ask what we can call as the judge. You can write here, ask the judge to explain his point of view. Right, to explain his point of view. Now, based on the complaint that he has received and based on the reply that he has received from the judge, if he deems fit that there is need to be a further action taken, he can refer the matter to the Chief Justice of India. That is the first thing. Second, if the complaint is directly made to the Chief Justice of India, in that case, again, the Chief Justice will refer the matter to the Chief Justice of the respective High Court of which the judge is a member of. And then the Chief Justice of High Court will take part in the same process. He will ask the judge to explain his point of view, then he will look at the complaints, look at the explanation, will use his logic and reasoning to understand that whether the matter need to be further investigated or not. Based on this, he will again send a reply to Chief Justice of India that further action and investigation is required. In the case of President, if the application is put, that is the third variant, President also again will refer the matter to the Chief Justice of India, who again will refer the matter to Chief Justice of High Court. Again, the same process will be repeated. So no matter to who the complaint is sent, the process remains almost same. It is the Chief Justice of High Court who has to do the due diligence, who has to prima facie investigate the matter. Now, suppose the Chief Justice of India has received the reply from the Chief Justice of High Court that the matter need to be further investigated because allegations seems to be serious in nature and actions are required. In that case, the Chief Justice of India then set up what we can call as a fact-finding committee. Now, these fact-finding committee to investigate the allegations and accusations are done by the committee, which is made up of two Chief Justice of different high courts, of which a judge is a member of, and one High Court judge. So, 3-member committee is there. Then this fact-finding committee submits the report back to the Chief Justice of India. Based on the report, the Chief Justice of India, if the report is, if the necessary action is required, he can ask the judge to take voluntary retirement. But if suppose judge refuses, in that case, Chief Justice of India will forward the matters both to the President as well as the Prime Minister of India to clear the path or way for the impeachment proceedings to be taken place. So that is how the in-house procedure works. That means if the failure of in-house procedure, in the event that the judge is not adhering to the in-house procedure, the matter can be again sent back for the impeachment, as we have discussed before. So that is all about this particular video. I hope you understood the overall controversy regarding the statement made by Justice of Allahabad High Court and what is the rectifying measures that we have available as far as the constitutional provisions are concerned. Thank you very much.